Good afternoon, everyone. Thank you for joining us today. My name is Catherine Zekier, and I'm a labor market policy analyst here at the Washington Center for Equitable Growth. We are a nonprofit research and grant-making organization dedicated to advancing evidence-backed ideas and policies that promote strong, stable, and broad-based economic growth. And today's event is a webinar on innovative strategies to enforce labor standards and protect workers' rights, featuring researchers Janice Fine, Galvin, and Jenn Round of the Center for Innovation in Worker Organization at Rutgers University. Their presentation today is based on an essay they wrote with co-author Hannah Shepard that appeared in Equitable Growth's book, Boosting Wages for U.S. Workers in the New Economy, and also a lot of the material was in a longer report that was released last fall, and we'll include links to both of those in a minute. But the Boosting Wages book was launched earlier this year in January, and it features 10 essays by leading scholars on policies to raise wages, but focusing on addressing underlying structures and dynamics in our economy from lots of different policy perspectives. So these essays, which were developed in partnership with the Institute for Research on Labor and Employment at the University of California, Berkeley, and with funding from the Bernard Nance Spitzer Charitable Trust, guide policymakers how to deliver broadly shared economic prosperity by making wages a key outcome to structural economic policy at the federal and state levels. So the book and all the essays, as well as a recording of the launch event, are all available on our website. Just going to include a link to that right there. And I will also get started just with a couple logistics notes. So this event is being recorded and will be available on our website afterwards, after a couple days to prepare it. And we will also send an email early next week with some of the resources mentioned in this presentation, links to reports, things like that. And also we'll include a link to the slides included. So in terms of just the webinar itself, please remain on mute throughout the presentation. And we'll start with the presentations from our three presenters on their research and policy recommendations. And then we'll have a substantial Q&A period to get into questions. So during the Q&A, you can ask questions in the chat. But also, if you want to ask a question out loud, you can just use the raised hand button to indicate that you have a question. And if you're not familiar with that, that's right at the bottom of your screen on the right, there's an icon labeled reactions. And then you can click on raise hand, and so it'll show you in the participant view. And then when you're called on, you can just take yourself off mute, but please tell us your first and last name and your institution or workplace when you start your question. So next, I would like to start just by introducing Janice Fine, who will start us off. Janice Fine is a professor of labor studies and employment relations at the School of Management and Labor Relations at Rutgers University, the director of research and strategy at the Center for Innovation in Worker Organization, and an Equitable Growth grantee. Dr. Fine researches worker organizations, historical and contemporary debates within labor movements regarding immigration, labor standards enforcement, privatization, and government oversight. She works across the country with government agencies and organizations to research labor violations in their jurisdictions and implement innovative labor standards enforcement strategies, including partnerships between government agencies and organizations, which we'll be talking about today. So prior to becoming a professor at Rutgers, she worked as a community, labor, coalition, and political organizer for more than 20 years. And with that, Janice, I will hand it off to you.
Thanks, Catherine. And thanks so much to the Washington Center on Equitable Growth, which has just been a dream partner for us. And we continue to really so appreciate your help and your support and the role that you're playing, particularly now, given the possibilities that have emerged just in the last few months. So across the US, workers and their communities are confronting historic levels of inequality. For tens of millions, work has become increasingly precarious and low paid. The decline of work has been shaped by a combination of firm and industry practices that include subcontracting and independent contracting, work for hire and gig arrangements, compensation and management by algorithm and through GPS, a stunning level of electronic productivity monitoring and surveillance, facilitating the centralization of control and the decentralization of production. And of course, the racism embedded in our labor market institutions and our employment relations practices. While there's been a proliferation of creative energy and innovation and organizing to pass new worker protection laws at the state and local level to combat these practices, such advances come with new challenges. Economic justice movements and their allies increasingly recognize that there is a significant gap between the work of grassroots and policy organizations to raise labor standards through legislation and anemic enforcement of these laws. It is here where we focus our research. When groundbreaking policies are hitched to backward enforcement regimes, their intended impact, especially for low-wage workers of color and women, is blunted. There is an urgent need to go beyond talking about what government should do to how government should do it. The Biden administration offers the best opportunity for progressive regulatory innovation since the New Deal. Addressing inequality in the labor market requires more than enacting strong substantive rights. Progressive policies can be designed in ways that create policy feedbacks, involve those directly impacted in implementation and enforcement, build relationships between agency personnel and key civil society groups, and incentivize organization. This is the work that we've been doing in the labor standards enforcement space, where 94% of private sector workers are not unionized and thus solely reliant on labor and employment laws and government enforcement of workplace protections. We originally did our study on violations during the Great Recession because we understood that high unemployment increases workers' desperation to maintain any job, thus tipping the power imbalance even further toward firms. So we wanted to better understand what to expect for workers during the COVID recession. What we found was disappointing, but not surprising. Workers of color, foreign-born workers, and female workers were disproportionately likely to suffer minimum wage violations. This story, though, is larger than a recession. Through our additional research on wage theft and enforcement, we have found that the same workers who are more vulnerable to minimum wage violations during a recession face greater probabilities of experiencing violations outside of recessionary times. Thus, we see effective enforcement as a critical component of economic justice. As we will discuss today, effective enforcement requires a combination of robust enforcement powers and strategies that are designed to reach those workers in high violation industries who are disproportionately likely to experience wage theft. We will start by reviewing our findings from the Great Recession, and then we will summarize a recent study we completed on minimum wage violations in Florida, where effectively no state enforcement is occurring. From there, we will discuss key enforcement powers that should be considered by advocates and policymakers when pushing to raise the minimum wage. Our conversation will then move to enforcement strategies, where our study of the deficiencies of complaint-based enforcement in San Francisco demonstrates the need for strategic enforcement. We'll conclude with a discussion of co-enforcement and related strategy recommendations for federal enforcement officials. So I'll pass the baton to my wonderful colleague, Dan Galvin.
Oh, thanks so much, Janice. So as she said, the unprecedented spike in unemployment in April 2020 motivated us to look into the relationship between unemployment and minimum wage violations, which is one of the most pernicious forms of wage theft. And so we first looked at the Great Recession of 2008 to 2010, where there was a steep increase in unemployment, followed by a slow, gradual recovery thereafter. And to see if there was any effect on the incidence of wage theft, we used the current population survey, which is widely considered the best publicly available data on wages and hours to estimate minimum wage violations among workers in the bottom quintile of each state's wage distribution. I'm happy to answer any questions in the Q&A about how we do this, how we estimate wage violations, and the steps we take to address measurement error and so on and so forth. But it's a pretty simple technique. And then what we do is we use those individual level data to estimate violation rates across states, across industries, across demographic groups, and so on and so forth. So here's what we found looking across states at the relationship between unemployment and minimum wage violations. We see a rather striking overtime relationship. As states' unemployment rates increased, so too did the average statewide rate of minimum wage violations. It increased from about 11% in 2007 to about 16% at the peak in the end of 2010. And then as the state unemployment rate began to fall, the average statewide employment rates began to fall, so too did the average minimum wage violation rate. slowly, tracking the slow recovery. But this is all at a pretty high level of aggregation. So in the next slide, we also asked, what's the probability that any given individual worker would experience a minimum wage violation between 2007 and 2013, conditional on their state's unemployment rate? And here what we see is that the probability ranged from about 9% to about 22%, depending on where and when they lived. Each percentage point increase in their state's unemployment rate predicted on average almost a full percentage point increase in the probability that they would experience a minimum wage violation. And the average amount of money they lost was about 20% of the applicable minimum wage that they were entitled to at the state or city or county level, which was about $1.46 per hour on average. And that's a pretty robust number year in and year out. Really, it's 20%. It doesn't vary very much. And of course, for a minimum wage worker to lose 20% of their income is obviously outrageous. But the violation rate is affected by many things, not just the condition of the economy of the state in which the worker works. So in particular, some groups of workers are more vulnerable than others, even within the same period of time. So we found that, for example, non-citizens during the same period were more than twice as likely to experience a minimum wage violation as US citizens. Workers who the CPS coded as Hispanic were 1.8 times more likely than white workers. Women and Black workers were 1.4 times more likely than men and white workers, respectively. When the interaction of gender, race, and citizenship are taken into account, the effects of discrimination are compounded. So Hispanic and Black women who were not US citizens, for example, were about 2.5 times more likely to experience a minimum wage violation than white women who were US citizens. So we know that immigrants, women, Black workers, and Latinx workers are disproportionately represented in the low-wage workforce. So to a certain extent, this is not surprising. And during a recession, when unemployment is high and these workers have few exit options, few alternative employment options, they may be more willing to tolerate wage violations for the sake of keeping their job, since a job that pays less than the minimum wage may be better than no job at all. But this led us to wonder, during better economic times, when lower rates of unemployment provide more employment options to workers, do violation rates continue to be disproportionately high for Black, Latinx, immigrant, and female workers? And so in a recent study we did with the Florida Policy Institute and Alexis Davis, who is here with us today, and here she is in the report, we found the answer to be yes, right? So what we did here was we aggregated data from 15 years from the entire period between 2005 and 2019. And we found that the same groups that are disproportionately likely to experience minimum wage violations in a recession are indeed more vulnerable to violations outside of recessionary periods as well. So the probability of experiencing a minimum wage violation was 1.4 times greater for a woman than a man, 1.5 times greater for Black workers than white workers, 1.6 times greater for Latino workers than white workers, 1.8 times greater for immigrants than US citizens. And Black and Latino immigrant women were 2 and 2.3 times more likely than US-born white women to experience the violation, respectively. We also found some important variation in the overall minimum wage violation rate in the state of Florida over time. So in 2004, Florida voters passed a ballot initiative to create the state's minimum wage for the first time in the state's history and raise it above the federal level, which at that point was $5.15, to bring it up to $6.15. And the increase took effect in April 2005. So between the year 2000 and the end of April 2005, the minimum wage violation rate among low-wage workers in Florida, that's before the increase, those with income in the bottom 20% of wage earners averaged 7.6%. So that's before the increase. After the increase, the minimum wage violation shot up. And by the fourth quarter of 2006, it was 13.9%. By the same time the following year, it reached 17%. wage theft of minimum wage violations hovered around 15% for several years thereafter, before climbing up to a peak at an astonishing 26% in 2015, more than 3 times the violation rate in the early 2000s. It settled back down again to about 15% in 2019, but that was almost double the violation rate 15 years prior. So after the minimum wage increase, the violation rate averaged 17%. What's particularly notable about all this is that in 2002, under Governor Jeb Bush, Florida abolished its State Department of Labor. The Florida Attorney General has sole enforcement authority for the state minimum wage, but in the last decade, it failed to take a single action to enforce the minimum wage. And as you probably know, in November 2020, Floridians voted to raise the minimum wage to $15 by 2026, which is fantastic. But as of today, the state still has no effective enforcement of the law. So I will pass it now to my fantastic colleague, Jenn Round.
Thanks, Dan. And I'm going to go ahead and prematurely apologize. My dogs seem to be barking a lot today, so apologies if that happens. So what do these two studies taken together tell us? As Janice mentioned in the beginning, effective enforcement is critical to economic justice. Passing a minimum wage law and other labor standard laws is not enough. Often, too little attention is paid up front to implementation. But to be able to do their jobs, enforcement agencies need legislative tools that help them to address barriers for workers that are disproportionately impacted by violations. Advocates and policymakers at the state and local levels who are looking to raise minimum wage in their jurisdictions risk seeing these gains significantly blunted for the very workers they are meant to help, just as they were in Florida, if they do not consider and fight for strong enforcement powers. And just to, next slide, please, Dan. Just as a little plug here, we do have resources that go into a lot of detail about powers that state and local agencies need in our labor standards enforcement toolbox. And we can send this out after the webinar for those of you that are interested. Next slide. So the same logic applies at the federal level. As exciting as the potential of a $15 minimum wage is after 12 years of stagnating at $7.25, robust enforcement will be crucial to ensuring that workers more vulnerable to violations actually receive the pay increase. This means that as advocates and policymakers push to enact a higher federal minimum wage, they must also be discussing and advocating for stronger enforcement powers so that U.S. wage and hour is best positioned to ensure that workers get the wages that are due to them. Again, we have a full list of policy recommendations in our longer paper on the Great Recession. And we also have a separate memo that's written for federal policymakers that we're happy to share with anybody who wants to read it. But just to briefly highlight a couple of powers that we think are particularly important in the federal context. The first is retaliation. Fear of retaliation keeps workers from making complaints and cooperating during investigations. When retaliation occurs and goes unaddressed, it results in a chilling effect throughout the workforce. Savvy, bad faith employers know that worker participation is critical to enforcement, especially in more difficult cases where the employer destroyed or failed to maintain accurate documents. And so employers may use retaliation as a way for preventing agencies from establishing the underlying violations. Such employers are undermining worker power and the rule of law. And without the ability to hold employers liable for retaliation, agencies are less effective in enforcing laws against the worst violators. Under most laws, however, retaliation is notoriously difficult to prove. To address this, a number of states and cities have recently included a rebuttable presumption that an adverse action taken against a person within 90 days of a protected activity was retaliatory. So that's the enforcement power, right? When an agency sees that an employer takes an adverse action against a worker within 90 days of that worker doing something that's protected, it's presumed that that adverse action was retaliation. So as an example, if a worker were to file a complaint or testify in an investigation, and within 90 days, the employer terminated their employment or reduced their hours, it is presumed under the law that the employer's action was retaliation, which the employer can rebut if they have sufficient evidence to show that they took the action for a legitimate reason. This presumption makes retaliation easier to prove and it better protects workers. In addition to rebuttable presumption, federal remedies for retaliation should also be expanded to better account for the collateral impact of retaliation. We have seen some states and local jurisdictions pass laws with more generous damages payable to aggrieved people. For example, Arizona's minimum wage and paid sick leave law requires retaliating employers to pay a daily penalty to each impacted person of not less than $150 for each day the violation continued or until the legal judgment is final. In most cases, such remedies are far more generous than what is allowed under federal law. One other statutory power that we think is particularly important involves giving U.S. Wage and Hour the authority to investigate wage theft more broadly, including enforcing state and local minimum wage laws when they're higher than the federal minimum. Currently, for non-overtime hours, Wage and Hour must use the federal minimum wage to calculate back wages due. So in states like Florida, where the state minimum wage is higher, but they don't have an active state enforcement authority, Wage and Hour is in the uncomfortable position of being able to recover only a portion of illegally owed wages. Empowering Wage and Hour to enforce the higher of the state or federal minimum wage for all hours worked better protects workers, but also our democratic values, especially in states like Florida, where voters pass ballot initiatives to raise wages, but politicians opposed to wage hikes are interfering with the implementation of these laws. And passing it back to Dan.
So in addition to enforcement powers, our research has also found that enforcement strategy is crucial as well as a component of effective enforcement. Unfortunately, we know that many of the workers who are doubly or triply vulnerable to discrimination and wage theft on account of their race, gender, and citizenship are either unaware of their rights or are fearful of complaining when they're underpaid, even in good economic times, which presents a problem for the enforcement model that's relied on by the vast majority of agencies, in which an investigation is triggered only after the agency receives a complaint from the worker. Even in some of the wealthiest and most progressive cities in the United States with well-funded agencies that have strong enforcement powers, we found that there are some stunning gaps between the industries with the highest rates of complaints and those with the highest violation rates. So working with the San Francisco Office of Labor Standards Enforcement, we replicated part of David Weil and Amanda Pyle's seminal article, their analysis from 2005, in which they compared the number of minimum wage complaints, in which we compared the number of minimum wage complaints that the San Francisco office received to the in the office between 2005 and 2018 to our estimates of minimum wage violations in the same industries during the same time span. And ideally, in a complaint-based enforcement system, we want everyone to fall into quadrants 1 and 4, right? The top left and bottom right. The most complaints should be coming from the least compliant industries, and the most compliant industries should be seeing the fewest complaints. What we don't want to see are industries where there's lots of non-compliance, but low complaint rates, which is quadrant 2. That's the really dysfunctional quadrant where we don't want to see complaints. But that's exactly what we found in private households, social assistance, and food manufacturing industries. In all 3 industries, it's worth noting, women, non-citizens, and people of color are disproportionately represented. And we can provide a link to this study as well. There are lots of reasons why these workers might not complain. But what this underscores is that the complaint-driven enforcement model is clearly failing to protect some of our most vulnerable workers who face multiple forms of discrimination and who can least afford to be underpaid. Another way to think of these numbers is that in the private households industry, for example, for every 1 complaint that was made to the San Francisco Enforcement Agency, there were more than 1,300 violations that occurred, we estimate, but went unreported. For every 1 complaint that was made to the agency in the social assistance industry, we estimate over 800 unreported violations. So these are workers who are falling through the cracks in San Francisco, which is home to one of the best and most experienced labor standards enforcement agencies in the country, across good and bad economic times from 2005 to 2018, all the data pooled together. In other words, we might think of these workers as always falling through the cracks. Back to Jen.
So how do we reach workers if a complaint-based enforcement model is not working? To reach workers who are experiencing high rates of violations but are unlikely to complain, agencies need a model of enforcement called strategic enforcement. Unlike complaint-based enforcement, in which each case is typically processed as an isolated incident, a strategic enforcement model analyzes complaints for underlying causes. Strategic enforcement also helps agencies focus their limited resources on high violation industries, influential employers, and common industry practices that violate the law in order to achieve sustained widespread compliance. Strategic enforcement addresses gaps created by traditional complaint-based enforcement in several ways. First, the use of proactive investigations and targeted industries means that enforcement resources are more likely to identify and reach vulnerable workers who are unlikely to complain. Second, proactive investigations are used in tandem with triage, a system for sorting complaints into different treatment categories to help agencies efficiently manage their resources so that high violation industries with both high and low complaints are prioritized. To be effective, this approach must be informed by data so that enforcement agencies have a firm basis for making decisions about where to dedicate their very scarce resources. Third, strategic enforcement recognizes that addressing the fissuring of employment relationships is key. This requires holding those with the most power and reputational risk in the contracting relationship liable for downstream violations. Most commonly, this happens through joint employer liability. Also, it's not enough to just have strong enforcement powers. I know that sounds very obvious, but we have seen many agencies that don't use or that grossly underutilize their enforcement powers. Strategic enforcement calls on agencies to reevaluate the enforcement powers they do have and to maximize the use of statutory tools that deter violations. Similarly, robust collections efforts are necessary to ensure that judgments are meaningful and that workers actually receive the money they are owed. Innovative settlement terms that address the root of violations and promote ongoing compliance are also key when they're possible, as is a press strategy to publicize the outcome of significant investigations to ensure that other players in the industry are aware of the repercussions when they violate. And now to Janice.
Strategic enforcement is a necessary strategy, but it will not succeed unless it is accompanied by a significant enhancement of worker voice. Initiating an investigation is merely the first step in the enforcement process. While proactive enforcement helps to bridge the gap between complaints and violations, worker cooperation after the investigation is initiated is crucial for establishing violations and defending the agency's findings on appeal. Simply put, problems will remain hidden from investigators unless workers speak up, but vulnerable workers will not speak up in isolation. Co-enforcement, formal and sustained partnerships between government agencies and civil society organizations embedded in low-wage workers' geographic communities and often focused in specific high violation sectors, is essential to addressing the enforcement challenges created by the 21st century labor market. Through their relationships and local credibility, community organizations and worker organizations can educate workers, encourage them to file complaints, and help to gather testimony and documentation. Drawing on workers' networks, community organizations can also encourage workers to cooperate in the enforcement process by providing a safe space, interpretation and facilitation services, as well as helping investigators meet with workers who may be too intimidated to engage with a government official on their own. They also exercise a kind of moral power and broaden public support for robust enforcement when they document and publicize egregious examples and patterns of abuse. In addition to the federal enforcement powers we discussed earlier, we also want to point to two strategies we think the U.S. Wage and Hour Division needs to adopt in order to effectively enforce the law for workers most vulnerable for violations. During the Obama administration, the U.S. Wage and Hour Division underwent an enforcement renaissance by pioneering strategic enforcement. However, in order to build back better and gain the trust of those workers who were targeted by the Trump administration's emphasis on immigration enforcement, co-enforcement at the federal level is more important than ever. As a first step in establishing co-enforcement partnerships, a grant program similar to OSHA's longstanding Susan Harwood grants should be created to fund partnerships with organizations that have deep connections to vulnerable, low-wage workers and expertise in high violation industries. From there, the division staff can develop the strong relationships and enforcement strategies that enable them to reach vulnerable workers, carry out the most effective investigations, build the strongest possible cases that result in fines and penalties high enough to deter violations and improve FLISA compliance across localities, regions, and high violation industries. In addition to partnering with community organizations, Wage and Hour must do more to coordinate enforcement efforts with state and local agencies. Currently, more than half of labor standards enforcement capacity in the US resides at the state and local level. By leveraging each other's resources and powers, agencies at all levels can achieve better results for workers. To do this, Wage and Hour should review and update its memoranda of understanding with state enforcement agencies that allow for reciprocal information sharing, maximize interagency enforcement efforts, and provide clear and accessible guidance to workers about their rights under specific federal and state worker protection laws. Additionally, a grant program should be created that supports state and local enforcement agencies to facilitate sharing of innovative strategies and practices. Such a program would promote more effective enforcement at all levels while enhancing the potential for coordination across agencies. This grant program should fund regular trainings and convenings to foster interjurisdictional relationship building and sharing of best practices, including the cost of travel and other logistics and full-time staff to organize and manage such events, and tools to facilitate coordination on interjurisdictional investigations, including technology upgrades and data sharing. Thanks very much. We're open for questions.
Great. Thank you so much, Janice, Dan, and Jen. So yeah, we're open for questions now. Please raise your hand in the through the reactions button at the bottom of your screen if you have any questions. We have lots of time to dive into this because I think there's so many places we could really dig into this. But I just want to say that one of the things that just really struck me throughout your work is that this is also just still a very crucial time. I mean, it's no longer we're no longer the place in the pandemic and recession that we were when your first report came out last September. But state and local revenues are down and will be down probably for a little while in the wake of that, and right when they're really needed most. And your research also shows that labor standards enforcement agencies have been asked to do more with less for a while now. So even though cities and states are raising the minimum wage, when you have that great progress, you're lacking enforcement. The stark example that Dan gave of Florida, where voters voted to raise the minimum wage in 2020, but the states had essentially no enforcement capacity or action for a while, I think is maybe an extreme example that shows this, but yeah, just shows the importance of having the enforcement side as well as the, if you want those minimum wage increases to be meaningful. And I can jump in with a question from Alex Goldworth, who had to leave, but she's Equitable Growth's Director of Family Economic Security Policy. And she writes that the research makes a compelling case that now is the time to improve our enforcement tools, but some advocates and policymakers may think that in moments where there's a possibility for legislative change, we shouldn't focus on or spend time on fixes that can be accomplished administratively. So how would you respond to that?
Jen?
Sorry, can you say that one more time? I was putting the Florida study in the chat.
Oh, excellent. Just saying that at a time you have a lot of recommendations, some of them are legislative, some of them are administrative. Some advocates and policymakers may think that now if we have a window or we have an opportunity to make legislative change, should we still be also focusing on the administrative changes?
I mean, I think yes, right? What we have seen in most instances that it's the easiest to get strong enforcement tools passed when you're also passing the substantive laws. It's much harder to go back afterwards and say, oh, we also want to add a rebuttable presumption of retaliation and a rebuttable presumption of a violation when an employer doesn't maintain records. after the fact. And without strong enforcement tools, you're left in a position like, like we've discussed, where those workers that are most vulnerable to these violations are not going to have, or potentially not going to have their rights enforced, right? And so in order to make these laws work for the people that we want them to work for, I think it needs to be part of the discussion. I mean, we also know, right, that politics and getting laws passed is, it's a game of trading, and you're not going to be able to get everything through. And I think that's why there are certain tools that need to be prioritized, and, the conversations had about what can be let go and what really needs to be in there, what you really need to fight for. But I would say that, right, these conversations need to be had in tandem at the same time. They're not isolated, they're directly connected.
Yeah, that's a great point. And we have a question from Steve Richardson at DOL in the chat, saying, I noticed your early reference to the strong connection between equity and labor standards enforcement. Have you weighed in, or what are your thoughts on the RFI for the Biden administration's equity executive order?
We think the executive order is very important. We haven't weighed in yet, but we intend to. We have been more and more drawn to studying the South in particular, where we think that there's an enormous disparity in terms of the installed base of both employment regulation and employment enforcement, and that the wage and hour division, the federal government, could play a really critical role in the southern states in providing more enforcement capacity. That's just one example, but we think that there are many, and that taking a racial equity lens really, really matters in this area, and will make a huge difference, right? Because it reinforces the need to do targeted enforcement and strategic enforcement and co-enforcement, because workers of color have been crowded into low wage sectors in the labor market where labor violations are rampant. So thanks for the question, Steve. And we have every intention of weighing in, but thanks for the nudge. Nudge.
Great. And yeah, keep asking questions. Can ask them in the chat or use the raise hand function. Yeah, I was also really struck by just how complaints that we see are often just the tip of the iceberg. The San Francisco study really shows this again, like you mentioned, a city that, a jurisdiction that is really doing a lot of things right and is really working really hard on a lot of labor enforcement issues. But, for every one worker complaint in the private households industry, if I read this right, you estimate that more than 1,300 violations actually occur. So also, are there examples of places, maybe in San Francisco, maybe elsewhere, that just some examples of cities or states that have implemented some of these strategic and co-enforcement efforts to reach workers in those high violation, low complaint industries?
Yeah, I mean, Jen and I can take this one together. What we would say is that the state that's kind of been really showing the way in the last 10 years is California, and that California has adopted deep into its work a strategic enforcement approach, as well as very strong partnerships on the ground with worker organizations that have expertise in certain industries. So its strategic enforcement work across 8 different industries at this point is done in partnership with worker and community organizations. And the results have been stunning in terms of the number of violations that have been identified. And Jen, will you help me out here with more?
Yeah, the number of back wages assessed and penalties assessed have also been much higher than ever before in the history of the Labor Commissioner's office. And we think, right, and that's an additional study we plan to look deeper into, but we think it's in large part because they're using those two strategies that we discussed in tandem, right? Both strategic enforcement, where they are looking at high violation industries. They're really assessing where they should be dedicating their very limited resources, and they're doing that in partnership with organizations who have very close connections to workers who are more at risk for violations, right? So, the way that it generally works is that the organizations themselves are talking to the workers that they know, that they have, that are parts of their communities, parts of their worker centers. When they're hearing about violations, they are then doing interviews with workers. They're identifying other workers whose rights have potentially been violated. They're collecting evidence, and then they're bringing that evidence to the agency. And then together, the agency is determining, the agency and the partner organizations are determining whether or not they should be, using their resources to do a full investigation. And like Janice said, these investigations, because they're done in industries where we know violations are happening, and because they're really doing everything they can to reach vulnerable workers, have been incredibly successful. And everyone hates it when you point to California, but California is just really, they've been able to do these things, together, strategic enforcement and co-enforcement together, and really create strong partnerships with the organizations who know these workers the best.
We're also seeing growing, we would also point to Massachusetts. Massachusetts is a kind of an unusual situation where it's actually the Attorney General, the Attorney General's office that does wage and hour enforcement. And Massachusetts is also very strong in terms of its work with community organizations and its targeting of low wage sectors. So that's another state. And what's exciting to us is that there are a number of states now that have become more and more interested in this. Washington State is going forward with a strategic enforcement focus. Jen, what's the other state that's going forward?
Colorado.
Yeah, and Colorado. So Washington State, Colorado are going forward with strategic enforcement. New Mexico has been doing some interesting things. New Jersey, my home state, is really focused on really trying to bring in strategic enforcement as a new paradigm across the entire Department of Labor in New Jersey. So we're very encouraged. Oregon making changes, we're very encouraged by what we're seeing on the ground across a range of places.
Excellent. That's great to hear. So we have a question. Peter has his hand up in the chat.
Thanks for this really vital work. I have one quick question. There was a stat that Janice, you mentioned about more than half of the labor enforcement capacity being at the state and local level. I was wondering if there's a particular source you'd point me towards for that, or if I should look in the book chapter. And then I was also wondering if you could speak to there's any instances where co-enforcement could actually kind of have positive feedback towards furthering worker organization or even unionization. You were framing it earlier as a supplement or a alternative when 94% of private sector workers don't have a union, right? This is what they do have to enforce labor standards. But I'm wondering whether there's examples that come to mind where having that role for worker organizations within the enforcement process can actually help them attract more workers or just build a broader organization through that.
Thanks for the questions, Peter. Both really excellent. Thank you. All right. So your first question. Years ago, Jennifer Gordon and I actually counted up as comprehensively as we could the enforcement resources at the state and federal level. And Dan and Jen and a colleague of ours, Hannah Shepard, are going to do this again in the coming year. But at that time, what Jennifer and I found was that it was roughly half, 50-50 at the state and little bit at the local level. That's very different now with the emergence of some of these larger local enforcement agencies. So you can find the site in Fine and Gordon. On your second question, this is something that we've been thinking about a lot, which is we think that there's a real opportunity when these laws are passed, whether, minimum wage, you study fair scheduling, all of the different, paid sick and safe time, all of the different policies that are being focused on. We think that there's a real opportunity to say that in sectors where violation rates are exceptionally high, domestic work, car wash work, food manufacturing, retail, other home care, right? In these sectors, that there needs to be a more of a turbocharged enforcement regime. So, for example, in California, the car wash workers law incented car wash agencies to create collective bargaining agreements, and they did this by saying that by requiring that those car wash agencies that did not have a collective bargaining agreement needed to provide 15% bond upfront to cover violations that might be brought later, because there's so much churn in that industry where companies go in and out of business. And so the idea was to have bonding upfront, which we see as a core strategic enforcement practice. But the law said that if an agency had a collective bargaining agreement, they didn't have to do that bonding. That's an example. In our view, with domestic work in particular, with violations way above acceptable levels, we think that there's an argument for requiring that employers participate in trainings and organization and sign contracts, and that domestic workers are given paid time, unpaid time to participate in trainings and in worker organizations, and that everyone knows that an organized labor market is a more compliant labor market. So we think that part of our worry is that the New Deal created systems and embedded a system in the economy for there to be ongoing negotiation and for there to be labor management discussion, and for there to be institutionalization of labor standards discussion, right, and negotiation. What we worry about is that now there's this spate of really creative policy being passed, but it kind of sits in policy. It doesn't nest in the economy. And it doesn't build structure the way that the New Deal did through the National Labor Relations Act. And so we're interested in how can we use enforcement agencies to embed structures. And that's something that we're very excited about. And we see the domestic workers trying to do this in Seattle and Philadelphia. And we see, efforts at doing this with retail workers and with fast food workers in New York City, and with drivers in Seattle when there were, and in New York City, right? So there's some effort to use policy to create structure, and we'd like to see more of that. Thanks for the question.
Thank you.
And we have a couple questions in the chat now. So one from Carla Walter, is wage theft prevention and wage recovery, is the Wage Theft Prevention and Wage Recovery Act the gold standard for a co-enforcement grant program, or are there opportunities for the government to do more with these partnerships, or does the federal government need to spend more? And Carla, if you want to follow up on your question anyway, please feel free to jump in.
Carla.
Yeah, I know. I've been trying to crib notes on what we should be doing, and thinking about this both in terms of how we can think about wage theft enforcement from the minimum wage standard, but also contracting wage standards. And as you probably know, there's a lot less in terms of private right of action and so on for contracted workers, but we really want to get smart about co-enforcement there. And so that's why I'm here today, so you can teach me all I need to know, all of you.
Jen and I actually worked a lot on that proposal and worked a lot on ideas about how to really attach strings and really try to strengthen labor enforcement standards and wage standards with federal contracting. And obviously the work you guys have been doing has been really exciting and important. But we have to say that we do think that the Build Back Better paradigm, we think, ought to allow for a huge uptick in the number of investigators, right? So for example, the ILO says that in advanced industrial economies like ours, the ratio of investigators to workers should be 1 per 10,000. So imagine in the private sector, if we did that, we'd be talking about 14,300 or so investigators, right? And so, you talk about a WPA, right? Or a CCC or like a jobs program, it would serve the dual purpose of doing something to finally address, this deep problem we have with violations in the labor market and a jobs program. So we think that we should be much more ambitious about numbers. And likewise, we think that if the federal standards are really going to stick, we think community compliance monitoring is essential. And we learned a ton from looking at how the Los Angeles Black Workers Center engaged in community compliance monitoring. And we'd love to see, and we actually wrote a whole proposal for, Jen, I can't remember, it was $50 million or $100 million that we thought annually should go to community compliance monitoring of public sector contracts. So we're with you, Carla. We think that there should be many more resources put into this and that this should be taken very, very seriously. I'll just say that last time around when ERA hit New Jersey, I came to despise that expression shovel ready, because I felt like that it meant that all the funding was going to low-lying fruit, and that really what it was going to take to get Black workers into these jobs, and not just hired, but also moving up in particularly in the building trades, was going to require intensive concentration, not just pre-apprenticeship, but on monitoring. We know, particularly with building trades jobs, that the sites change all the time. People go on and off. And so we think that it could be incredibly exciting and important. And as you guys have done at CAP, right, open up a whole new area of exciting, innovative work. Thanks.
That's super helpful. Thank you.
We have another question in chat from Todd Blue about how do you assess the challenges, but also the community building potential of co-enforcement strategies in the context of Black Lives Matter and the greater scrutiny of policing and the criminal legal system in the United States. So related to that, what might successful co-enforcement look like? And Todd writes, I can imagine difficulty in creating partnerships between law enforcement agencies or DA offices and workers of color, for instance, even around combating wage theft.
Well, so I would just say first, right, the enforcement that we're talking about is not criminal. It's administrative and potentially civil. So there is that distinction, right? Like we are talking about enforcement, but it's not going to it's not criminalizing people. Although there are some types of, there are some laws that do criminalize wage theft. And there was just a report, I think, released yesterday that was about DAs working with, that using the criminal statutes to prosecute wage theft when wage theft is egregious. I think what you're saying about the difficult in creating partnerships is true. We talked to one DA recently who was really interested in changing his office and trying to figure out what would it mean, to earn the trust of community organizations and to do enforcement of wage theft where there was potential trafficking involved or it was an egregious case. And what we heard from him is that he had been reaching out to community organizations, had been meeting with them, and they weren't really interested in that route. We've also heard in one state where, community organizations that were working with an administrative agency, there was a criminal case that was sort of involved the same employer that came in. And when that happened, all of the workers stopped participating in the administrative case, right? So it is incredibly complicated. And I don't think that there is an easy answer. And I think, criminalizing wage theft is something that should only be done when it is a case that is, obviously incredibly egregious, and needs to be done in a way that's not going to alienate or otherwise endanger the people that are trying to be helped. I don't think that, I'm not like, I don't, because we think more about administrative wage theft, I don't have like a great answer about the criminal side of it, except to say that it's very complex. And I think it's going to take a lot of time and a lot of effort on the, from DAs and police officers to be the people that are, making those connections with community organizations and leading the way, right? Community orgs aren't gonna probably are not gonna be the ones reaching out to DAs. It needs to be the other way around.
Yeah, that's a really interesting point. And to go back a couple questions in the chat, Steve notes, Steve Richardson notes that to give context, the idea that Janice mentioned having 14,000 investigators with sort of that ratio standard applied. Currently, US DOL Wage and Hour Division only has about 1,000 investigators. So that's just a sense of how much progress, what the opportunity is for how far we could go on this.
And we had 1,343 in 1978. Yeah. When we had, geometrically fewer workers and firms. Yeah. Thanks, Steve.
And
Jesse, I'd love to, can you come on and talk about, just say a little bit about what you say here in the chat? Oh, you're muted.
Can you hear me now?
Yes.
Thank you so much. This is so helpful for me. No, I was just, something that has been coming up a lot for us lately is that the federal prosecutors are still prosecuting people for working under Social Security numbers that are not their own, even in cases where, they're prosecuting them for identity theft or document fraud. There was just a press release, I think last week, about an individual, I think this was in Missouri, they're publicizing it. So like they're proud of it. And this was a case where there was no, I think we have to make a distinction between identity theft, where the person, for example, takes out lines of credit and is actually trying to kind of, as opposed to someone who's using it to work and earn wages, and that's the only reason that they're using it, right? Because one of the things that we're working really hard on right now is trying to get DHS to create a program that would provide protections against deportation and work authorization for people who come forward and participate in labor disputes, right? As an anti-retaliation mechanism. And one of the things that we're confronting is that the workers are afraid to come forward because there's no way to immunize them against some of these other potential consequences of revealing that they've been working, under assumed identities. And I mean, roughly half of all undocumented workers are working under assumed identities. They're not completely off of the books. And so what does that mean then about our ability to enforce on their behalf if, even if they're not in an adversarial proceeding with the government, if their employer is in an adversarial proceeding with the government, wants to call them as a witness, and then the employer wants to cross-examine them, for example, they can get into this whole thing of, well, didn't you work under an identity that's not your own? And then, are the state, and especially in the hostile states, we're worried about state prosecutions as well. So it's just a whole kind of knot that we're trying to unravel.
Jen, you want to say anything?
I mean, no, that was really helpful point. And yeah.
did you guys, I'm trying to think, Jesse, we have a whole set of papers in our labor standards enforcement toolbox. And we have long papers about retaliation that really focus on low wage immigrant workers. I know you kind of wrote the book on this and we quote you, but I wonder if you've looked at, because we tried to come up with every creative idea that we could find that was out there. I'm not sure that we've come up with things other than what you have raised, but we definitely tried to. But it's also why we think that I don't like this expression, but third-party complaints are so important and company-wide investigations are so important, and that there has to be recognition that it's high time for state and local and federal to make every effort to support workers who come forward, and retaliation is the biggest reasons why they don't. Everyone knows that, and that's why in part we proposed amending the Fair Labor Standards Act, among other things.
And I actually wanted to follow up on that because we've talked a little bit about why it's important to have administrative changes along with your legislative changes. And we've talked about sort of, actions at different levels of government, but I think those conversations can often be very siloed, very naturally around, here's what you can do at the local level, here's what you can do at the national level. But your research really shows the importance of sort of not just everyone doing their part, but like how the different levels and different parts of government all are necessary to enable the actions and to promote the actions the others are taking. So could you talk a little bit more about, you have some recommendations around amending the FLSA, the Fair Labor Standards Act. And so could you talk a little bit more about what, for instance, Congress can do to help state and local labor enforcement?
Well, sure. I mean, I think there's like a few things, right? I think one thing that has been, I don't know if benefit is the right word, but it's been really interesting to see, and that Janice and I have been looking at, for the last 3 or 4 years, is that because there's been such stagnation at the federal level, it's really let the cities and states do some interesting things, right? And so a lot of these enforcement tools that we talk about in these papers, they actually are already happening at the state and local level, right? Those came from innovations from people that were, being pushed by worker advocates who understood that, there were specific barriers for a lot of workers to come forward. And so, so I think at the federal level, there's a lot of looking to what the states and localities have done and figuring out how they can incorporate those practices and some of those powers into their laws, right? Which is a lot of what we wrote about in the paper and what we talked about today. One thing that we didn't talk about as far as powers go at the state, we've seen in a few cities and a couple of states, is this like there's a rebuttable presumption of retaliation that we talked about, but there's also the city of Seattle, for instance, has a rebuttable presumption of a violation where the employer doesn't maintain the records that it's required by law to keep, right? So you think about an employer who's a bad actor. They're not going to keep good payroll records. In fact, they may have falsified payroll records. They may have double books. They may have no books. They may destroy records as soon as they hear that the agency is going to be investigating them. And that means that for the investigators, it's going to be really difficult to, one, know who all the workers are. And this is especially true if the agency isn't working with a community partner who's going to help identify those workers, right? But like, who are the workers? Just figuring that out is going to be a huge problem if you don't have records. Two, how many hours did they work, right? If you don't know who the workers are, if you're not able to get in touch with them, you don't have their contact information, how do you know how much they worked? How do you know, how long they had worked there? How do you calculate back wages? So some states and cities have created this presumption where when the employer doesn't maintain the records as required, there's a presumption that the employer is in violation. Now, you still are going to have the problem of calculations, but a lot of times, because the employer is presumed to be in violation, if you have any evidence, like if you can find some of those workers, you can use their testimony because that's the only evidence that you're going to have, really credible evidence. Use the worker testimony to sort of rebuild the records and determine how much is owed. let's see, other tools that we've talked about is a longer statute of limitation also at the federal level. States like New York have a 6-year statute of limitation, which can mean that, where workers are working for an employer who hasn't paid their wages for a long time, they can actually be more fully compensated for those violations, right? So that's another interesting and helpful tool that the federal government can look at. Janice, what else is there anything else?
Well, I think you should talk more about the idea that it doesn't make any sense. If you have places where the wage and hour division is enforcing, and in those places there's minimum wage higher than the federal minimum wage, then they should be enforcing to help workers get what they're entitled to.
Yeah,
and that is the higher minimum wage. So
wage theft, that's the big one, right? It's wage theft. So a lot of states and localities can enforce, not just their own minimum wage, but they can enforce worker promises to pay and compensation owed to workers due by reason of employment, right? So the federal wage and hour they're not able to enforce promises to pay. So if an employer says, I'm going to pay you $20 an hour, but they end up only paying the worker $10 an hour after the worker has completed the work, well then, at a state and city level in some places, again, like Seattle, San Francisco, LA, California, they can go to the agency and can actually get the money that they were promised, because that's wage theft, right? At the federal level, that's not possible. And then again, going back to the state wages, right? So where the states and cities have passed higher minimum wages, and there either isn't any enforcement capacity, or there isn't enough enforcement capacity to get to all of the complaints or the workers whose rights have been violated, then the federal wage and hour is coming in and they're only able to get $7.25. So in places where they actually have passed a $15 minimum wage, you're looking at less than half of what's actually owed to those workers for non-overtime hours, which is ridiculous.
So I see Kate Bronfenbrenner has her hand up. Kate is an inspiration to me for many, many years, and a incredibly important resource about union organizing. Kate, what's your question?
So I didn't know whether you had looked at the idea of compounding. These super violators are also normally super violators of multiple employment laws. And those of us who were proposing something like this in the past had thought about that those who violated multiple labor laws, so OSHA, NLRB, wage and hour, that there would then be more serious financial penalties for those who violated multiple federal laws, and criminal penalties for those who did that. Is that anything that you had thought of and proposing? And second to that is that these are political agencies, and that they do respond to pressure from workers organizing against them, so that when the actions are actually taken against them, not when the organizing is putting pressure on these agencies, they do respond. So that's the 2 points I wanted to make.
Jen, you want to comment about Kate's first question?
I mean, we haven't looked at the federal level, we haven't looked at penalties that would be for, like, what you call them, super violators, but I think that's a genius idea. What we've looked at more is when an employer is a repeat offender, or when they're violating more than one law enforced by a single agency. But what we have been, kind of researching and thinking about is sort of this interagency enforcement, right? Where you would have potentially OSHA and wage and hour investigating together, going in together, or potentially having one investigator who's able, who has the authority to investigate for both agencies. And then you could potentially leverage the penalties under all laws to get as great of penalties as possible. I had never actually thought about, additional penalties when you're violating multiple federal laws at once, but I think that's a genius idea, and one that everyone should be, writing down. I know I will. And I think to your second point, for sure, right? Like one thing that we've seen in California that was really impressive was, the collections rates in California. I think there was a report around 2013. I think the collections rates were like 22% of what was owed to workers was actually getting to workers. And so the community organizations who had been working with the labor commissioner to bring cases, they came together and they said, this is unacceptable. And they helped write a bill that eventually was passed that gave the agency really strong collection tools. And then the agency was able to hire someone from the community orgs that came in, is now leading the collections. And it's really revolutionized, the California's ability to do collections, and giving them all these new, really creative, really interesting tools that we haven't seen, we haven't really seen anywhere else. So yeah, I think, and that's another sort of plug for co-enforcement, is when you have these organizations that are so deeply immersed in enforcement, they see exactly where the breakdown is happening, right? Like where the agency isn't able to do, like where the agency is having problems. Is it resources? Is it is it the powers? Like, what is it? And then they can go in and use their own political leverage to change that, right? To make the agency more effective.
We agree with you also on unitary enforcement, right? We think that's really important. And I see that Steve says they're working on that. So Steve, I'd love to hear more about what people are thinking about. In France, for example, and the Dominican Republic and other places, there's an investigator will walk into a workplace and they're thinking about all the labor laws, and they're having discretion about what they're going to focus on, but they can enforce across a range of laws. So Steve, you want to say a little bit about what you guys are thinking?
Sure, and it's been really interesting. I've been at labor a long time. I'm the analyst at the department level for wage and hour, but I've worked with OSHA probably more than I have wage and hour, and I'm involved in a number of work groups, the equity work group that I mentioned earlier, but also we have a data board. And kind of the latest thing, and as you know, this stuff moves very slowly at the federal level, but we're well aware how siloed we are. And of course, OSHA has huge challenges in terms of their authority, wage and hour less so, but there's a recognition that, they inspect a lot of the same folks and that they really ought to be talking to one another. And so for several years now, they've been working on how do we formally, like in a database, share this kind of information. And, wage and hour is, I think, the only DOL agency that I can think of that has their own chief data officer. So I know him well, and they're doing some really good work. And then we have now a chief data officer for the department who's, convening a large group. So there are a lot of challenges. A lot of it's just with getting our systems to speak to one another. And then even at the federal level, we're having a data inventory, and the whole idea, in addition to making data available to the public and researchers like yourself, it's making the data available to investigators. As far as joint authority, like I haven't really heard any of that, like having a wage hour investigator ready to enforce safety violations or, log and pursue those kind of things. But from a data standpoint, we've been working on it for a while, and we are making some progress.
Yeah, I just want to say that you're not alone in the issues around tech. We hear that from agencies all over the country. It doesn't matter their funding. It doesn't matter whether they're local or state. So hang in there. We hope it gets better.
We always joke that we go into these state agencies and there's one person who can get the database to work and who can print reports, and everyone else in the agency is terrified of them, terrified they'll leave, constantly kind of tiptoeing around to make sure they don't offend them. So another thing that the federal government could do is that we talked about is funding states to do database upgrades. It would make an enormous difference. And I'll just say that from our perspective, what's really important is, as Kate was saying, that in a workplace where there are wage and hour violations, there's likely to be health and safety violations. We know this is true. And so there has to be We need to think about root cause labor enforcement. And that means that, we need to target in on those sectors where we know that violations are rampant. So strategic enforcement, again, we think gets to the root of those issues. And obviously David Weil and the Wage and Hour Division and OSHA under David Michael were pioneers on this, right? And the question is like, this time around, can there be a real focus on partnering with states and localities, right? That's what didn't happen last time to the extent that it needs to. Two-way information sharing and much more cooperation and really thinking much more creatively about how to work together. So I know Todd has been patiently waiting.
Hi, thank you so much for the amazing, very informative presentation. I guess my question is kind of related to what everyone else was talking about or already around like data collection. But one of the issues that I've run into trying to like research wage theft is there's just not a lot of data. It's not out there. It's collected by many different agencies, and sometimes when you file freedom of information requests to like specific states, they don't even have the data available. And so I wonder, like, what steps, if any of you all had any additional thoughts about what steps do you see being taken to obtain accurate data collection on wage theft, and if not, then what agencies do you think might be best suited to pursue this? So thank you.
Dan, you want to start?
Well, I don't know. I mean, that's why we turn to the CPS data, right? It's because we think the complaint data is obviously biased, right? And that's sort of trying to point out in these reports. Employer data is, also biased. As you said, you can't get great data from the states. So I don't know, there's a good study that was done by, Annetta Bernhard and colleagues, but that's really hard to replicate. And, that did a snowball sample with enhanced methods, really hard to do on your own. That took a long time and a huge research team and sophisticated methods. So I guess it depends on what are you trying to do, and what exactly are your research needs? If you could quickly say.
Oh, I guess for myself, it would be like, one of the things is I'm interested in seeing is like, to what extent all these laws being passed around wage theft, like there's a lot of laws being passed around the country, are they actually having a beneficial effect? So we can kind of assess that.
Well, I wrote an article on that, but I use CPS data, right? And so using CPS data on minimum wage violations, because that's the best use of it, and you can do a difference in difference analysis, right, around it and see if there's a significant change before and after. It's not perfect. I mean, it's not an experiment, but it's sort of trying to replicate it. I'll send it, or I'll put it in the chat, a link to it, so you can see what I did. But there are other studies that are better out there that you can try to replicate.
It is a huge problem, however, and it's something that we talk about all the time, and that we're thinking about all the time. And it contributes to the, like part of our mission is to discredit the paradigm of complaint-based enforcement, right? And so the way we've been compensating for the lack of data is to do the CPS data instead, right? But it's a huge issue, and it isn't just about resources, right? It's also about what states are actually taking seriously their role, a role in ensuring that workers are paid for their work. Sorry, Catherine. So is there, are we through the queue?
Yeah, I think unless anyone has any other final questions, yeah, we'll send around, I said this in the chat, but we'll send around links to the big reports we mentioned today, for instance, the toolbox that Jen and Janice mentioned earlier.
Also, Catherine, there's 2 papers of Dan's that are just outstanding. One is about wage theft and what policies kind of move the needle. And the other is about the shift from labor to employment policy. These are groundbreaking articles that many people on this call will find super, super helpful in the work they're doing now.
Thanks, James. I don't know if that's true, but I appreciate the shout out. Here's the second one. Put that there. Thanks,
We'll include those as well. Great. So yeah, if there aren't any other questions, thank you all for joining us today. Thank you to Janice Fine, Galvin, Jenn Round for a wonderful presentation. Fantastic. And to our audience for just really interesting discussion. I put a link to the report that we've been discussing, those, the basis for the discussion today in the chat. And I can do that again, but you can find the essay and the report on our website. Also links to the other Boosting Wages essays. And if you are, want to keep talking about ways to raise wages, we have a really interesting event next month. That's also part of our Boosting Wages event series, and it spotlights research from economist Robert Manduca on place-conscious federal policies to reduce regional economic disparities. That will be on Wednesday, June 30th. We haven't sent out an invitation yet, but we'll do that soon. And you can also just receive updates for all Equitable Growth events and publications through our website, and there's a link there. But yeah, thank you everyone so much for joining us. Have a wonderful rest of your day.
Thanks again.
Thanks, Catherine.
Thank you so much.
Thanks.